This Honorable Court of Appeals of Tennessee is in session.
Good afternoon, all. Before we call the case, just a quick reminder that while we don't anticipate any technology-related problems, our experts have got it down pretty smooth nowadays on Zoom. That if we should have any, everybody will just take a deep pause and they'll work us through it and get us back going. This hopefully will be the last time in our March docket, and of course, about the end of March, this will probably be the last. This hopefully will be the last time that we Court of Appeals hears arguments by Zoom, as we're going back in April to in-person oral arguments, which we're all frankly looking forward to. Zoom has been a wonderful substitute in a very difficult time, but we're glad to be moving back towards there. Call the case, please.
Tennessee Farmers Mutual Insurance Company versus David Payne et al.
We'll hear from the appellate.
Ryan Zaharovich, Your Honor. We've requested 4 minutes for rebuttal.
Yes.
Good afternoon, Your Honors. The underlying case here involves the tragic death of Amy Higgs' 5-year-old son, Kaysen Turnmeyer. Kaysen died following a series of negligent actions by homeowner David Payne, including his failure to fence his property, his failure to put a gate on his freestanding deck, and a failure to put a fence or an alarm around his pool. These were all alleged specifically in the underlying tort complaint. After suit was filed, Mr. Payne's insured, Tennessee Farmers Mutual Insurance Company, filed the instant action seeking a declaratory judgment as to its duty to defend this claim. There are two related but distinct issues before the court today, and that's first, did Ms. Higgs adequately plead in the underlying tort complaint that some covered act or omission was a substantial cause of Kaysen's death? In St. Paul Fire and Marine Insurance versus Torpoco, the Tennessee Supreme Court made clear that the determination as to whether an insurer must defend a claim is based solely on the allegations in the underlying tort complaint. It's clear that Ms. Higgs has alleged that Kaysen's death occurred due to Mr. Payne's concurrent negligent acts. Specifically, Ms. Higgs alleges in paragraphs 11 and 13 of the complaint, which are record volume 2, 182 and 3, that Mr. Payne's breaches of his duty included failing to have the fence around the property or gate around his freestanding deck. The second question is, did Tennessee Farmers adequately contract around the concurrent cause doctrine? In their policy, which I'll explain in detail, Tennessee Farmers failed to include any language whatsoever that would contract around this established doctrine. The Western District of Tennessee found in Ski Chalet Village Owners Club Inc. versus Employers Mutual Casualty Company, the purpose of this anti-concurrent cause provision is to inform the insured that there is no coverage for damage that is caused in any manner by an excluded cause, regardless of any other concurring or contributing cause. Tennessee Farmers is not cited to one case where language remotely similar to the language used in Mr. Payne's policy led a court to conclude that an insurer contracted around this doctrine. There are an entire line of cases that I'll address with clear, specific language that show what an insurer must do to successfully contract around the doctrine. As a starting point, there is no question that Mr. Payne's policy contains an exclusion for claims or damages arising from or in connection with the swimming pool on the insured premises. And there's no question that certain negligent actions arising in connection with that swimming pool were a substantial cause of Kaysen's death. However, under the concurrent cause doctrine, Tennessee Farmers still must defend this claim. That doctrine, which was established in Allstate Insurance Company versus Watts, where the Tennessee Supreme Court found that when a non-excluded cause is a substantial factor in causing an injury, even though an excluded cause also contributed and standing alone would have properly invoked the exclusion, the insurer must still cover the claim. After Watts, this court in Planet Rock Incorporated versus Regis Insurance Company clarified why Tennessee Farmers must cover this claim today. That case involved an insurer refusing to defend a claim where an individual was knocked unconscious in a nightclub, dragged outside the nightclub where the assault continued, then brought back in the nightclub where he ultimately died without any aid being rendered. The club's policy contained an exclusion for damages arising from assault and battery or any act or omission in connection with the prevention of such acts. While the insurer, like they do here, argued there would have been no death but for this assault and battery, the court found that the insurer had a duty to defend the claim because the complaint contained an allegation that they failed to render medical aid, which was also a concurrent cause that led to his death. Just like the insurer in Planet Rock, Tennessee Farmers argues there would have been no death but for an excluded clause, negligent maintenance of the swimming pool on his property, on Mr. Payne's property. They say in their brief it was the only cause that was required for the drowning to occur, as in Planet Rock, where an assault was obviously the only cause for his death from the injuries stemming from the assault to occur. The question is not what is the only cause, the question is really, are there any other causes that substantially and independently contributed to causing the injury?
What are those non-excluded concurrent causes?
And the non-excluded concurrent cause is failing to fence his property.
Was there an allegation that that would be negligent not to put a fence around your backyard if the pool wasn't there?
It's not alleged in light of the pool, and the complaint is just alleged it was independently negligent for him to fail to have a fence. And in his deposition, it was discussed that as you could walk freely between the properties.
I understand, but was the allegation was that what made not having a fence negligent was the fact there was a pool in his backyard?
The way that it's worded in our complaint is that it was negligent the negligent action was failing to fence the property, and it wasn't specifically tied to because they had a pool in the backyard. Now, of course, a lot of the complaint is tied to because there's a pool in the backyard, but an important aspect of all this is that we wouldn't be here talking about this had Kaysen walked up the deck and fallen and hit his head on the deck. This can't turn on whether there was a swimming pool in the backyard or not, because that's not how the concurrent cause doctrine is applied under Tennessee law in the cases.
I'm just asking, what was the concurrent cause, the negligent concurrent cause? What was alleged? You're saying it was failure to have a fence around his backyard?
Yes.
And that's okay, even if the only thing that makes it negligent is the presence of the pool?
Well, we'd say that's not the only thing that makes it negligence. That obviously was a contributing cause that led to the injury. But the question is, was there an allegation of negligence in the complaint that led directly to the injury here, which we'd say did? That fact that he did not have a gate back there was a decision and a negligent one that allowed Kaysen to access his property, and the failure to not have a gate around his freestanding deck was another negligent decision that allowed for Kaysen to access the deck.
So you allege that it was just negligent for a homeowner not to have a fence around his or her backyard, period.
That is what we've alleged, and it's based on the allegations in the underlying. Now, of course, we'd have to prove this at trial, and we'd have to prove that was an allegation of negligence that's substantiated. But we believe under these circumstances, it was negligent.
Well, but is that a question of fact? Or a question for what does the trial court look at when you say the complaint alleges it was negligent not to have a fence around the yard, even if no matter what, pool or no pool? Does the trial court just have to take that as true?
That's the standard in determining whether the concurrent cause doctrine applies.
And then your conclusion that it was negligent?
It's similar to a motion to dismiss standard, really, that the allegation is there and they take the allegations in the complaint as true. At that point,
the factual allegations.
Right. And the factual allegation that he did not have a gate surrounding his property.
Okay. Go ahead.
But what you're hitting on is exactly right, is the difficult aspect of the concurrent cause doctrine. There's always an excluded substantial cause of injury. You don't need to render aid following an assault if there is no assault. Well, we'd argue that you need a fence around your property and your deck, regardless of whether there was a swimming pool, due to any number of risks that exist on the property. The question is not what was the manner of death or the order in which the alleged negligent acts occurred in relation to the injury. The question is simply, did the plaintiff plead that some covered act substantially led to an injury, which it did here? As the Sixth Circuit said in Atlantic Casualty Insurance Company versus Cheyenne County, the concurrent cause doctrine requires insurers to defend their insured if any alleged cause of injury would be covered by the insurance policy, regardless of how many excluded causes are also in the complaint. We take each allegation of negligence separately is what has to be done. And if it led to an injury, then it is an excluded cause. It can be a non-excluded cause even when there is an exclusion in place. The only time the court finds that the concurrent cause doctrine does not apply is when all of the allegations are explicitly excluded, like in St. Paul Reinsurance Company versus Williams. That was a nightclub shooting case where there was an exclusion in the policy, excluding claims arising out of assault or battery, including allegations of negligent acts by the insured in connection with supervision or prevention of the assault. There, they alleged there was not security, and that was very clearly covered by the exclusion. So logically, the concurrent cause doctrine did not apply. Here, of course, Ms. Higgs has pled the existence of these other covered causes, and it should apply. And the question becomes, did they contract around it? When looking at whether they contracted around it, insurance policies are strictly construed in favor of the insured. And Farmer's entire argument essentially is that because they have in connection with the pool in there, that's enough to put their insured on notice that the concurrent cause doctrine, which applies by default, would not apply. When looking at the situation.
Counsel, I'm sorry, what was the excluded negligent clause that you all alleged?
That he fell into that they didn't have an alarm on the pool or a gate specifically around the pool.
All right. So that was as to the pool, but the fence around the yard was just a fence around the yard.
It did not arise. The decision not to fence the property did not arise from or arise in connection with the swimming pool. And that's the tough part with the concurrent cause doctrine. Everything's going to always circle back to that. There is an excluded clause at the heart of it. But the reality is that this other cause also contributed to an injury here. Okay. And as far as the exclusion language, in the cases where they find they contracted around it, there's clear language in them. In the Atlantic Casualty Insurance Company case, it said, if any actual or alleged injury arises out of a chain of events, including assault or battery, regardless of whether the assault or battery is the initial event or a substantial cause of injury, any actual or alleged injury arising out of the assault or battery as a concurrent cause of injury, regardless of whether the assault and or battery is the proximate cause of injury. There's clear case law existing on what you need to put in these policies to contract around this doctrine. The doctrine's been around, it's not new, and it existed prior to the implementation of this policy. They simply did not include any language that would have put their insured on notice that it was not going to apply. And now there's no way to say that, of course, one of these causes is in connection with the swimming pool. That's a fact here. But when there are allegations of other causes not in connection with the swimming pool, then the concurrent cause doctrine applies to allow the claim to continue. And we should be entitled to put that proof on at trial in this case.
Thank you, counsel. You have your time for rebuttal. We'll hear from the appellee.
Thank you, Honor. It's a pleasure to be here. Andrew Owens from the Memphis County Bar Association for the appellee. Well, I first got to take issue with counsel's representation of his complaint. I believe when you look at that complaint, the only fair reading of that is that the negligence, alleged negligence of not having a fence is couched in terms of the pool. Paragraph 5, defendant Payne's home at 7411 Independence Drive had an above-ground swimming pool in the backyard. Upon information and belief, defendant Payne did not have a fence or a gate around his pool or his property. Rather, he had a deck that partially surrounded the above-ground pool, providing easy access to the pool. Then you get on down paragraph 11, the Cason's death approximately caused by defendant Payne's failure to maintain his property and pool in a reasonable, safe manner. Goes on to cite various ordinances. Paragraph 13 deals with common law duties, and they're all dealing with the pool. There are some ordinances and building codes that apply only to a swimming pool, to a fence being required when there's a swimming pool. I couldn't, at least that's been the best I could determine from my research. Some of the codes aren't set out there, and it's hard to find some of them, but it's our assertion that a fair reading of the complaint is that this is all about the failure to have some barrier prohibiting someone from coming to the pool. And as I stated in my brief, when you start talking about substantial causes, there's nothing negligent, and I know of no law or duty to have a fence or a barrier to one's property per se, standalone duty. Now, this is just this concurrent cause doctrine is like all of our other interpretation rules, insurance policy and contract interpretation rules. And I just think that Judge Kite Brown put it properly when she said in her ruling, quote, "It is clear that the endorsement expressly excludes coverage, and the court finds no ambiguity in the words, quote, arising from or in connection with the pool or its applicability in this case." We say we did draft out the any allegation or any applicability of this concurrent cause doctrine Has anybody shared a screen before the Court of Appeals before?
I don't believe so, counsel.
You want to try it?
Sure. If you're up for it, we're up for it.
All right, let's see. Can you see my cursor moving?
Yes, sir.
That's a good sign. Well, this is the amendatory endorsement. I know you can read, but I'll read it anyway unless you tell me to stop. Subject to all other terms of the policy to which this endorsement is attached, you and we agree that this endorsement is a part of the policy when it is designated in the declarations and you pay any premium due. Any term in the policy in conflict with this, with any provision in this endorsement shall be of no effect and inapplicable. The provisions of this endorsement are specifically stated in the declarations and identified with this endorsement number. Description: personal liability and medical payments to others coverage provided by this policy shall not provide protection for any claims or damages arising from or in connection with the swimming pool on the insured premises. And then it goes on to say that any other terms of the policy remain unchanged. Now, I think somewhere in one of the appellant's briefs, they refer to that clause. You know, to say that the terms are unchanged doesn't conflict with the terms are inapplicable and of no effect. So we see no conflict there between the language, any term in the policy in conflict with any provision in this endorsement shall be of no effect and inapplicable. We see no conflict with that and the phrase any all other terms of the policy remain unchanged. I'll go on, and unless y'all want me to leave it up, I'll stop sharing that screen so you can see a nice big picture of me.
That'll be fine, counsel.
Thank you, Judge. It occurred to me the other night. It seems like the plaintiffs want us to use legal language in these insurance policies, the concurrent clause doctrine or substantial cause. And that runs contrary to what insurance companies are told to do. They're supposed to make their policies understandable to the common man. And it occurred to me, superior drafting involves a broad description that stays away from the particular. You may consider this a silly example, but suppose an insurance company, there was an area where the trees fell over a lot, and they wanted to exclude damage to the structure for trees being blown over. Well, you could list every tree on the planet, I suppose, by its genre, its species, or you could describe that thing that you're seeking to exclude in a general term. But not to beat that point, I think we say the policy did that. This policy is, the language is plain, it's simple, and it's easily understandable. As Judge Kite Brown said, and we think as is self-apparent, anybody can look at this and see, and they don't need to know about Watts or Travelers or Planet Rock or what the concurrent cause doctrine is, or when is something a substantial concurrent cause or when it is not. They can look at that and tell, okay, I got no coverage for any claims or damages involving this pool. Our assertion is that that's plain language. So we say that we say that we did. If we're hung up on the concurrent cause doctrine, we did draft around it or over it. I like to think we drafted over it. We drafted a policy that anybody could understand, and it is the intent of the parties and the expectation of those involved in it. And of course, we've cited Hornbook law. Endorsements kind of stand out. They're intended to change the base policy. They're intended to get your attention. And there's some case law that terms in an endorsement that might conflict with the base policy become or take precedence. So, the case that ushered in this doctrine, or at least it's the one most cited, Watts, and those cases and Travelers involved arising out of. We're not suggesting the use of the but-for clause. That's probably a good ruling when you've got an insurance policy that only says arising out of. But ours goes further and says, or in connection with. I think that Watts cited Travelers for the proposition that Travelers was saying that when you're talking about arising out of, it takes more than a mere connection. Well, we got connection. We got that language in our policy. So I think we might have satisfied the court in Travelers since they said a connection won't work when you're looking at arising out of. I think even if you analyze this case under the concurrent cause doctrine, you come away with the conclusion that these other causes are not concurrent causes. The courts have made it clear they have to be a substantial cause. And I like what Watts, we like what Watts said. And that's an interesting, you'll remember, you can't hardly forget the facts of that case. Some folks are, I think, redoing their brakes in a garage of a home, and one of them accidentally ignites a pan of flammable liquid nearby, and a fella picks it up to move it and spills it on another person. And as the court said, the same harm could have resulted had Watts been cutting any number of objects in the garage with the torch, completely unrelated to the truck. In that case, they were trying to get coverage under a homeowner's policy, and Allstate took the position that no, this was arising out of the maintenance or use of a vehicle. And the court said this could have happened anywhere. Well, the opposite is true in our case. These other alleged causes are not substantial causes. People climb over fences all the time to get in swimming pools. Most of the time we do it at night. I told on myself, but these other causes we assert don't fall under the definition of a substantial cause. This again, we're not hanging our hat on the but-for test. It's in connection with. There's a mention in plaintiff's brief about this language in the Planet Rock case where they were talking about in connection with, I lost my notes. I think it said any act or omission or attempting to suppress an act or omission. This doesn't refer to that type of connection. This refers to the pool, in connection with the pool, not a specific type of act or oppression. Now I need a little guidance. I'm not going to do this if it's improper. One of my associates found a nice little case. It doesn't change the law. I gave it to counsel this morning or midday because it's the first time I'd seen it. I know the rule says if I find a case after I have filed my brief, I send the clerk and all the judges a letter and the other lawyer with some things in it. So if I shouldn't mention it now, I won't.
No, you're free to mention it, but if it's not contained in your brief, just send a letter to the court clerk. You don't need to send it to the judges, but send a letter to the court clerk and opposing counsel, and don't argue the case. Just give us the name and style of the case and say this is a case you referenced in oral argument.
Okay. I know that rule said not to argue it. Can I speak briefly about it here?
Oh, you can here. Yes.
Okay, thank you. Well, it's Pennstar versus Willis. A tree cutting company was out working, and a young man, they had taken a log and put it under one of the wheels of their tree cutting machines. And then when they were trying to get it out, they had trouble. And so he ended up using his personal vehicle to try to pull it out. When he pulled it out, it flew around and hit some guy in the leg and broke it. And so you had a suit. And the lawsuit alleged, according to the appellate opinion, the lawsuit alleged nothing about the issue was he was using his private vehicle to do this, and there was exclusion in the business policy under that. And the lawsuit mentioned nothing about him using a car. It's almost as though they were prescient and knew the arguments that we'd be making here today. They talk about negligent in using a log the way they used it, negligence in not getting pedestrians, standers-by out of the way. And the Court of Appeals just said it's clear here that the only substantial cause was this young man's use of this vehicle. Again, it's fact driven. It doesn't really change the law, but it's an example, we assert, of how the court analyzes this substantial cause. And I know I've got time left. I've got my guitar over here to the left if you have any requests. Otherwise, or if you have any questions, I'd be glad to answer them. Thank you.
I hear no questions or requests either. So we'll hear from you for rebuttal.
In response to that, what we would say is we're not asking for legal language in the contracts. We're asking for language sufficient to put an insured on notice that the concurrent cause doctrine will not apply, which is what every single case that has addressed this issue has said. Opposing counsel can't point to any case where they've allowed for an insurance company to circumvent the concurrent cause doctrine that does not include this language. And in fact, the only other case that used the language in connection with the Planet Rock case did apply the concurrent cause doctrine there. That's just what the standard is on these cases, because they have the power to draft this contract and they need to put their insured on notice. In connection with is just like arising out of inherently an ambiguous term that could be interpreted in different ways and must be in favor of the insured as it's interpreted. As far as the Travelers case, that is the case they primarily rely on. That case has nothing to do with the concurrent cause doctrine. It was decided years before the concurrent cause doctrine was brought to Tennessee, and is a dispute between a home insurer and auto insurer as to who must cover a claim when a shotgun went off in somebody's vehicle. There, they found that coverage was still appropriate even when an exclusion existed in the policy, saying that nothing arising out of the use of the vehicle would be covered. And they found there was coverage there under one of the two policies, but it has nothing to do with interpreting the concurrent cause doctrine. Determining whether an exclusion applies to bar coverage when there's one alleged cause of injury requires a completely different analysis from determining if an insurer has included language sufficient to notify its insured that they want to contract around an established doctrine of law. As to the last case that counsel cites, I believe it was sent to my old email address at my old firm. I did see it a few minutes before when it was forwarded to me to co-counsel, but in quickly reading it, my understanding is that the underlying complaint did involve allegations involving the automobile. And in fact, summary judgment was granted on those allegations. And then they tried to file a motion to alter or amend the summary judgment. And on appeal, they raised the issue saying, well, hey, they should have looked at these other allegations we now have that are unrelated to the automobile, including a failure to warn that we were about to use an automobile here. That's not this set of facts. And opposing counsel's right, it's a very factually intensive case, and it's an uncited case as well. The only cited case on this issue is Planet Rock, which could not be more on point with the issues before this court. But for an assault in that nightclub, that individual does not die, and the insurance company was obligated to cover that claim because of an allegation, an independent act that they did that also contributed to his death. We have to look at each independent allegation separately. They're all going to be tied back to, because we're not arguing that he didn't drown. He drowned in the pool, and that is a substantial cause of his death. But the failure to do these other things were also substantial causes that led to his death. They didn't arise from the swimming pool. They did not arise in connection with the swimming pool. The swimming pool is relevant to all of this, but he made those decisions, and those negligent acts are why we filed this lawsuit as much as anything else. And in the complaint, what opposing counsel, when he read from, it didn't just say and the swimming pool, it said or the swimming pool. Failure to maintain his property or failure to maintain the swimming pool, both were contributing causes that led to our client's death. And that's why they're obligated to defend this claim, which is a far different standard whether they have to pay on it, but they're obligated to defend this claim, and it should move forward based on the established Tennessee law under the concurrent cause doctrine. And I have nothing further unless there are any questions, Your Honors.
Oh, I hear none. The court's thanks to counsel for both sides. We appreciate your briefs and your oral argument today. I think we understand the issues and the parties' positions. If you would please adjourn court till our next scheduled case tomorrow.
This honorable court stands adjourned.
Thank you, counsel.
Thank you.
Thank you.
So we're not in session now. Judge Stafford, how much longer are you going to practice? You and me been at it a while.
Well, we'll just have to wait and see.
Ask my wife when I'll retire, I guess.
I understand.
All righty. Thanks again. Good to
Thank
see
y'all.
you.